Kate Avoles. I am another of the attorneys from Bakke Norman. This is Jeff Cormell. He is our law clerk that is working with us right now. I know nothing about implements of husbandry. Just not a thing at all. This doesn't have anything to do with that. So I attempted to dive in it back there, and I think we just started discussing reports about moving into a new apartment and how to document damage. So we clearly went awry. What I am here to talk to you about is, first of all, writing your own ordinances, having your municipal attorney write ordinances so you can issue citations for things going on in your community that you don't agree with. This is nuisances within the community. So we're talking about noise violations and animal issues and 7 trucks parked on the lawn and the neighbors don't like it, and things that make your community a less pleasant place to live in. There's a list that was put out by the Municipal Court system in Dane County that lists a lot of possibilities for things that you're looking for. They can be animal control violations, they could be building codes, they could be more along the lines of pseudo-criminal type violations, disorderly conducts, first offense, drunk drivings. Then you get with parking and traffic, trespass, truancy, underage alcohol. So there's sort of a broad variety, a broad spectrum of things that you can issue citations for if you've laid the groundwork to do that. And the first thing you have to do is lay the groundwork. And there is a municipality that's within Polk County, and they had an issue with someone who was raising dogs, and they were loud, and they were hound dogs, and they were loud, and they were disturbing people. Well, they had an ordinance in place for noise violations, but they had no way to enforce it. So they issued the noise violation to this individual, and I'm not even sure how they picked the amount of the forfeiture. Fines, just for your reference, fines are for criminal citations, forfeitures are for civil citations. So they issued this, asked for the forfeiture. They didn't have a court to prosecute it in. They didn't have a place for the forfeiture even to be paid. So had the person agreed to do it, I don't know if they would have just walked it over to the neighbors or if they walked it down to the town board meeting and said, who wants the check? There was no place to do it. So it's sort of a toothless citation if you have no way whatsoever to enforce it. And so that's kind of what we're going to talk about here. And when we're getting started, can I just, by show of hands in here, how many of you live in a municipality that has a municipal court that they can use? One. Okay, and where are you from? Glenwood City. And you, sir? Roberts. Okay, all right, okay. Anyone else? All right, so if you don't have a municipal court of your own that you can use, there are a couple different things that you can do. One is you can piggyback on somebody else's local municipal court. So if there's a municipality near Roberts, they don't want to go through circuit court for everything, but they also don't want to spend the time and the resources to start their own municipal court. You can make arrangements with another municipal court and say, okay, we're going to agree to prosecute all of ours through your court system. That has to be an agreement with that town, with their city or municipality attorney, municipal attorney, and the municipal judge agreeing to do that. But it's also extra funds for them because then they're taking a bit of the forfeiture amount to help fund their court. That's probably an easier way than starting up your own, and it's a little less involved than going through the circuit court process, and some of that money then will be coming back to you. So there are a couple of different ways to go. If you are going to go through the circuit court process, the first thing you want to do is contact the clerk of court in that county, wherever you are. Don't do anything else. Contact them first, because they all have different individual processes that you need to go through, different information that they need before they can get you started. So when we were talking about the kinds of citations, for very, very few municipalities is this going to be a money-making thing. It's just not going to, and for those of you who think it is, it doesn't end up being that way for several reasons, unless maybe you're in Somerset and you're prosecuting underage drinking and first offense OWI during all the summer music festivals, in which case, yay for them, but it's not very often, it's not very common that you can do that. So when you are drafting ordinances or for citation issuance, think about what your community actually needs. Animal control violations are fairly common. Building code, maybe, maybe not. It depends on sort of maybe the age of your town, the structural upkeep of the buildings. Is that something that's necessary? When you're looking at disorderly conduct and first offense drunk driving, there are a number of statutes, criminal statutes, that can have an ordinance level violation. So it doesn't have to be prosecuted criminally. You can adopt those as ordinances and prosecute them through the municipal court or through the circuit court using municipal citations, but you can't just do it for anything. There are certain violations that have minimum sentences, minimum requirements as far as prosecution, and they're not allowed to be prosecuted as non-criminal. So if your county decides they're going to prosecute OWI firsts, no problem. Those are considered traffic citations in Wisconsin. They're not criminal. But you can't then issue a citation for an OWI second because by law, those have to be criminal violations. So those are things that you need to look into, consult with your municipal attorney, have them look them over and decide whether or not you can do that. But essentially, if you have an ordinance that you have drafted and someone is violating that ordinance, then you need to enforce it by issuing a citation. If you don't, it's the toothless citation that we talked about before, where you're asking them to pay money, but there's no one to pay the forfeiture to, and you don't have any plan in place for enforcing it. Okay? The first thing that you need to do is to look to see, do you even have an ordinance in place that allows you to issue citations? Jeff, if you would just pass out. We've brought a sample of a town citation ordinance. We've blocked out all the identifying information, but before you can start issuing citations, you have to draft an ordinance that allows the municipality or the town to do that. There are several requirements that have to be found in these ordinances. The statutes, the regulations for that are found in Wisconsin Statute 66.0113. It's listed within this ordinance itself, so you can see that you don't have to remember it here. But first of all, you have to list the purpose. The purpose is allowing you to issue a citation. Then you have to decide, you have to cite the authority under Chapter 66. You also need to decide who in the town gets to draft and issue those citations. Okay, so how many here have local law enforcement? Anybody? Local law enforcement. So for the rest of you, do you rely on county sheriff department enforcement? Okay. People who can issue citations are members of the town board, if that's what you decide to do. And this is really up to you. This is where you look at your own community and say, who makes sense in this community to issue this citation? Is it going to be members of the town board? If you have local law enforcement, do you want them doing that? Depending on what the ordinance is, make it fit. Is it going to be a zoning commissioner? Is it going to be a fire commissioner that needs to do this? I will tell you that if you have sheriff's departments that you're relying on, they are very hesitant to start serving citations for municipalities. They don't like to do it. It's really hard to get them involved. So while you may list them as a possibility, that's wonderful, but you're going to have a hard time finding anyone who will follow through and do it. They don't want to get involved. So it's better off for you to find people on your town board that can do it. That doesn't mean that they are the ones physically going to the home and handing them the citation. Notice can be received by mail. Notice can be documented and designated within your ordinance. But this is just talking about who is going to put pen to paper and write this ordinance. So designate those people within the ordinance itself. Then you have to decide, if you'll look under Section 5 on here on the first page, what information has to be on that citation. And citations themselves, Jeff, do you have the copy of the little citation with you or not? That's okay. It just looks like an old-fashioned speeding ticket, you know, on the half sheets. And on those, you designate what kind of information you need. You need to have the name and address of the person who is allegedly violating the ordinance. You need to have the facts in this one. Okay, this is one version. This is not the be-all, end-all of what ordinances should be. This is what this town has decided to do. On those little tickets, there's not very much room to give you a factual premise of what this is about, but basically the name and address of the violator, what the allegation is. So if it's the noise violation, dog barking too loudly, I mean, it can be very brief just to give the idea. The time and place of the alleged violation. If you have a dog barking violation or you have something that is been parked permanently on someone's lawn, it's not going to be one day. You can say, you know, date of notice of violation. So the first time that it's raised to your attention, the first time someone notices that that is going on, that can be your date of violation. Just include that. Number of the ordinance violated, and a designation of the offense in a manner that can be readily understood. So name your ordinances with common sense. They need to know what they're being accused of. What is not listed in this ordinance, oh, okay, it is on the next page. You also need to know when they're going to appear in court. This is not a random time. This is another reason why you talk to that county, the clerk of court, before you do this. In certain counties, every Wednesday from 9 to 11 is municipal court. You just need to pick a Wednesday morning at 9 o'clock for them to appear. That gives them enough time, normally 10 days, to respond to this, okay? So you're gonna need to know date and time, whether or not they need to appear. And then the amount of the forfeiture. The amount of the forfeiture, and we'll get into this a little bit more later, this is not the amount that is just coming to you. There's a lot that needs to be included in the forfeiture that's listed on that citation beyond what the base forfeiture is for this violation, okay? We've talked about, is there a municipal court available, okay? Best case scenario there is. If not, you go through the circuit court. What the circuit court is going to ask you to do is, if you have a citation procedure, follow it. But if you have not yet set up essentially an account with the clerk of court, you need to do that before you can process a citation through the county. So they are going to ask you to submit all the ordinances that you have drafted. So the ordinance that allows you to issue a citation, that needs to go to them, and any ordinance that you wish to enforce. So if you have parking ordinances, if you have noise violations, if you have how many cars can be parked on a lawn, anything like that, if you're going to try to enforce it, they have to have it there. At some point, you may be enforcing it in front of a judge, and they need to know what that ordinance says. So it can be a very large packet of information going to the clerk of court. It can be a small one. It just depends on how many ordinances you have and how many you want to enforce. The next thing that you need to do is let the clerk of court know who is authorized. So it may be designated in your citation ordinance itself that says the president of the town board can do it, sheriff's department can do it. This is more of the practical, this is the name of our town board president. He will be issuing this citation. And as those positions change, you don't have to change the ordinance itself, but you need to let the clerk of court know if there's a different person that could be issuing those citations because they're given ID numbers. And those ID numbers are put on the citation. Yes, sir.
Does every county have to abide by this, having a county circuit court? If you go into them and say you want them to take care of these ordinances, I live in Barron County, just visited with our district attorney. She said absolutely not. The only way that you can get enforcement of this is by having a municipal judge, and the sheriff's department did the same story from them. They're not going to have anything to do with town ordinance.
That is not true. So sorry, but you were given bad information. In fact, I'm working with Barron County right now to develop these situations for 2 different municipalities. And it is Sharon Millerman is the clerk of court there. She's a very kind lady. She is very helpful. But yes, the DA is not going to enforce a citation like this if it's a municipal ordinance. They're not going to do that. And the judges there have, and in fact, that was the example I was using, Wednesdays from 9 to 11 in Barron County, they have municipal court. And the judges are there and they hear municipal citations. Terry?
If I could just comment on that. The key
Sure.
difference there is that you can't, DA's not going to enforce it.
Yeah.
And their sheriff's department is not going to write the citations
No.
and enforce it. You have to hire your own
Right.
And you have to issue the citation yourself. But the court up there will handle it.
Yes. And that was why I said you can put on your ordinance that the sheriff's department is a valid person to do it, but they won't. They don't want to, and they don't want to be involved. So you have to have your own city attorney or your own prosecuting attorney to handle that once you get into the court. And you have to actually have someone who's willing to draft the citation. You can give them the authority to do so in the citation ordinance, but you also have to find somebody who's willing to do it. So,
And that's kind of why when you ask for a show of hands,
yeah,
I think we've seen a couple of villages
yeah,
that said that they have that capability, but I don't think you're gonna find many towns, because we're looking at this very serious.
yeah,
And I think maybe the best way to do it, that we're looking at, is trying to get maybe 3 or 4 towns together to get a municipal court
Sure.
to put this together.
sure. And in that case, you're going to need some assistance, and you're going to, I don't know what the process is for starting up a municipal court and designating a municipal judge. That would be more Terry Dunce back there. He does that. I do the litigation aspect of things. And when Terry gets into a situation where it goes from the dispute at the municipal or the town level to we need to get into court, that's when I come on board. And in a couple of these different towns lately, that's been the issue, is now they've got a house that has a slough in the backyard and has 3 buses on the lawn and have neighbors that are sick of the sort of the vermin that's been around there and the eyesore that it is. And the town says, oh, okay, well, now what? Now what do we do? And they have an ordinance in place, but they have no way to enforce it. So that's when they called, and Terry said, okay, Kate, now what do we do? And I said, hey, Sharon Millerman, what do we do? And I called the county, and she said, this is what we have to do. So we've been doing this for multiple different towns now and setting them up. And it's not a huge process to set it up through the circuit court. It isn't, but you have to get that done before you start issuing those citations. Otherwise, you're toothless. Yes,
And the town's gonna be on the hook for all the costs too.
right.
It's a cost, it's not a moneymaker.
Right. And actually, I sort of led with the don't think this is a moneymaker for you, because it doesn't, because you end up paying the attorneys to go in and argue these citations and enforce the citations in court, which is another thing, is it just from a strictly financial aspect, if you're going to do this and you have several citations that you want to issue, and usually that's how it'll come. All of a sudden, people realize, oh, we can issue a citation, and then the things that have been pestering come, and this one, and then this one bothers, and this one bothers. Issue all the citations for the same appearance date. Send your attorney one time. Don't send them every week for 6 weeks to do it. Pick the same date and send them at the same time. Have them make one trip and only pay them for that amount. The other is when you are working through the county, I mentioned earlier that court costs are tacked on to what you think of as the forfeiture. So if your base forfeiture says it's $50 if you violate this, right? $50. Then you go on and you can go to wicourts.gov, and that will list the court costs for the counties all around the state. And so for Barron specifically, there is a $5 fee for every citation that is kept by the circuit court as just a procedural fee. If you issue one person 5 citations, and you decide after negotiating with this person that they're gonna plead to 1 citation and you're gonna dismiss 4, they keep $25 because you issued 5 citations. So for each of the citations you issued, they keep 5 for each, no questions asked, even if you dismiss them. Then there's $25 just for blanket court costs. There's a $10 jail fee. No one goes to jail on ordinances, but there is a $10 jail fee that's associated with this, even if you can't possibly go to jail. There's a $13 fee for the crime lab. I have no idea what about a dog barking violation would ever be submitted to the crime lab, but $13 to the crime lab. There's $68 for court support, another $21.50, and then at the end of that, your $50 forfeiture, when you issue the citation, you have to ask for $200.50 because that's what it gets you down to the $50 that you wanted for the forfeiture. So there is a bond book that you can order. It's free publication, and at the back of the bond book, it will give you an idea that if your county has this court cost, it's just a grid. If you want to charge $50 for this, you have to charge $248, and you just do it, and that's how you write out the citation. But if you write out the citation and don't include that, you're getting nothing. And it's probably not going to get processed through the court at that rate. So that's something that you need to be careful of. Jeff is going to tell you what you do from the time you get the complaint to the time you get the citation, and then I will come back and bring you through the court system. So we'll go through that afterwards. But Jeff, any questions thus far? Oh, sure, go ahead.
Can you write a citation at $50 plus court costs?
No.
Okay.
You have to include the,
It
yep,
has to be fully encompassing.
yes, has to be encompassing. Yes, sir.
As I listen to you, I'm hearing, why bother?
Well, why? No, well, yes and no. Why bother unless, it depends on the level of frustration you've reached at that point, you know. If it's something that is mildly irritating, why bother is exactly the right question. But if you're living next to something and there are rats running all over your lawn because it's gotten to the point where it's unlivable, then bother. But you have to get this in place. And what I have been talking about, this isn't something you do every time. This is something you do to get your feet on the ground, to get up and running. Once it's in place, you issue the citations, you call the attorney who would prosecute and say, you know what, we've had to issue a citation, we're going to need you in court that day. Probably the better plan is call the attorney and say, can you be in court this day? And then put the initial appearance date on. But this is just the first time through. Yeah.
You always have to have an attorney? Do you always have an attorney fee then?
You always have it. You need to have a prosecutor that's in the courtroom. Yeah.
You can't just do it yourself?
No, you can't. Yeah. You can have non-attorneys draft the citations, but you can't have the non-attorney go to prosecute it in the court.
Can they have an initial appearance, though some counties do, without having the prosecutors there?
That is true.
Citations. They'll just tell the people when they come in, you either plead not guilty, no contest, or guilty. If you plead not guilty, then we'll set it for the hearing where the lawyer would be.
And Tim can take over the last 20 minutes of this because that was going to be the enforcement to the court. Now he's my spoiler. But yeah, go ahead.
Is that an additional charge?
Is what an additional charge?
Is that additional charge to do that what he said?
Yeah, well, depending on how you have your fees set up with your municipal attorney. So
You have to consider that to be an additional.
you do, which is why I said if you have a number of them, set them up on one day, pay the attorney one time. Because whether they're being paid hourly or on a flat fee by citation, yes, you are going to pay that attorney extra to do it. Terry.
To comment on the why bother question, you know, to some degree, it's the local government's duty to bother under some circumstances, depending upon how bad the violation is. It's their duty to step in and do that. That's why they exist. They exist to build roads. They exist to keep the public safe. That's why the local government exists. And it's a duty when it gets bad enough.
And as a community that wants to invite other people to come and live there, you want it to be the most attractive, inviting community that you can. Otherwise, why do people do community projects and update their main streets and decorate their road? And, you know, it's an inviting thing. Go ahead.
Setting a precedence too, that if one person gets cited, another person may think twice before they do it.
Absolutely.
So I mean, it's also setting a precedence within your municipality as to what it would be.
Yes.
Does the cost for the attorney to be represented at the initial appearance depend upon the complexity of the issue? The more complex, the more cost?
No, an initial appearance is it's a very short appearance if you go at all. Sometimes you don't have to. Sometimes you just issue you're guilty or not guilty, and then the court, if they plead guilty, they take care of the forfeiture from them through the clerk. If they plead not guilty, they give notice to whoever that attorney is that says these 4 people came in and pled not guilty. Contact them and set up a time to discuss things with them. So the initial appearance itself is just a matter of entering a plea. It is not a time to argue the case. No one is bringing evidence. There's no sort of trial setting there. It's just a matter of getting in front of the judge, acknowledging that you have received that citation, that you understand what it is, and then entering your plea for the court. Yes.
I met with my court commissioner in Pierce County yesterday, and he told me that if I wanted to issue a citation, and if it gets issued, and I've gone through all these processes, getting the date and all that, then when, for the first appearance, we appear before him, and he told me that the town, a representative of the town had to be at the hearing, or he would just dismiss it.
And that's why you check with your court every single time. And like I said, in some instances, they don't have to be there, and in others they do. But that's why every county has their own different rules, their own different picadillos about things. It's the same way no matter what area of law you practice in, you have to respond to the county rules. So that's just one of those cases you check in. So Jeff, if you want to take over, and I will come back up. Oh, I don't think I...
Thank you. Okay, I'll keep it brief so we can kind of keep moving, but I am Jeff Cormell. I'm the law clerk at Bakke Norman. I mostly do research for the firm. I do a little bit of drafting of some documents, but so when it comes to legal questions, probably save those for Kate when it comes to litigation and things like that. However, though, I'll just kind of keep moving along here. There we go. So what I'm going to talk about is really kind of how this process begins. When the complaint comes to the town board. So generally these are angry neighbors. This might be the board itself noticing someone that's been doing something that you have an ordinance to cover. Could be an implement of husbandry that's destroying your roads, which I really don't want to dive back into. I'm in over my head already on that. But generally this is the angry neighbor syndrome. In law school they always tell us one of the number one lessons you can learn from property is be good to your neighbors, because they're the ones who are going to turn you in. And that's kind of the reality. If you have a dog barking, or you have abandoned junked vehicles in your yard, you have piles of debris and brush, who's angry about that? Your neighbors are. So as the town board, you're going to receive complaints, you're going to receive calls. I'm sure this is something you've all experienced at one time or another sitting on a board. What happens at that point, if you're going to go down a citation route, is you need to get some sort of a documentation begun at this point. An initial investigation, that could be as simple as just going and taking pictures of whatever the nuisance is, documenting, like writing a note, getting that to your clerk to have that put into a record, having a record begun on the process. So if this does reach a citation and you do have to go before the court, your prosecutor has some kind of evidence to rely upon when they're in front of the judge. If it's just word of mouth from the neighbor, that's not going to really make a great case if this does go before a judge for someone pleading not guilty. The thing you really need to have in place first, though, as we've already discussed, is that citation ordinance. What's in your ordinance, if you look at the examples you have, the process is really documented in that citation ordinance. What you're required to do as the board, what you have the opportunity you have to give the alleged offender to defend themselves, to give them their chance to speak back to the board, to challenge, hey, I'm not guilty. Giving them that opportunity, that due process to challenge whatever's been alleged against them should be part of that citation process. And getting to the why bother comment, excuse me, yep.
Do you have to have the ordinance in place? Like, can somebody be grandfathered in? If you see there is a problem, can you make an ordinance and then take care of that? Or do you have to have your ordinance in, or is that person grandfathered in because he did it before the ordinance?
Well, it depends on, I suppose it depends on the offense, but no, if you have an ordinance in place and
Say you don't, but then people see something and they come to you and say, we want something done. You don't have an ordinance in place. Can you deal with that issue, or is that issue grandfathered in?
yes. It's not grandfathered in. What it is, you can create the ordinance and then prosecute if the ordinance still, or if the nuisance still exists.
Okay, so then they are not basically grandfathered in?
No.
Okay, that was.
Yeah, okay, sorry. I was getting a little confused there. But so part of this process is then notifying, we say the source of the nuisance, but this person, letting them know. I mean, talking about why bother, in this process, if you're giving this person an opportunity to clean up their yard, to do something about their dogs, to do something to kind of satisfy being a good neighbor, is ultimately the goal. And if you can't get that done through a discussion with the person, the citation is there as like a last line of defense. The fine or the forfeiture that's going to come along with the citation is the, I hate to say it, but the stick you can kind of wave. The notifying the source is that opportunity where you say, look, your neighbors are complaining about you. This is the time to go clean that up. This is the time to get your dogs under control. Whatever the nuisance is, this is your opportunity to take care of it. That person then should have an opportunity to say, hey, wait, this isn't what's happening at all. That's not an abandoned truck. I do drive it every week, or it's still runnable, or it has licenses. This is their opportunity to come back and say, I just have a neighbor that doesn't like me. This isn't really what's going on. You got to give them that opportunity. So these first three things, these three bulleted, written response, public hearing, and time frame for available response, those are all parts that if you have an existing ordinance and those aren't in there, you might want to amend the ordinance. If you are going to draft a new ordinance, these are three things that you should consider. Again, the written response goes into the record. That becomes part of the evidence. That is the written response from the alleged offender. The public hearing is something that some counties choose to do, where you'll have part of the next town board meeting. This person will be on the minutes. They have the opportunity to come before the community and talk about whatever the nuisance is and be heard by the community. Do you have a question?
But that's just coming to a board meeting, not specifically stating it as a public hearing?
Well, it depends on what's in your ordinance. It could be, right. Yeah, I mean, these aren't requirements. These are suggestions based upon some of the ordinances we've seen. That might be more of a step than your county or your town or village wants to go. It might be exactly what your town and village wants to do. It depends on really, the community you're dealing with and what the community wants. The time frame. It's very important to let someone know after you've issued that initial notice, you have 10 days to respond. You have 2 weeks to respond. If you expect this process to keep moving, you have to set time frames for this to occur. Plus, if you're going to issue a citation, it's really important to let that person know, hey, 3 weeks from now, if this isn't taken care of, we're going to issue the citation. It shouldn't be a surprise process. It should be something they can anticipate and do the things that they can do to alleviate the situation or remedy it with their neighbors, however they have to go about it. And this last one, deciding whether to proceed, this is kind of an internal decision. This is that, why bother kind of conversation that the board should have. It's a cost-benefit analysis. If we keep going with this, this is what we're going to have to pay the attorney. This is the court fees we're issuing. And once that citation is issued, you do owe the court cost for the $5 or $10, whatever it is, depending on your county, which is a nominal fee if something is settled before. But it's something you got to consider at that point. And it's what kind of a community you really want to have. Do you want to be the town board that's issuing a bunch of citations, or is the citation just the process to get this conversation started with this person to have them alleviate the situation? I mean, and it really depends. These are people that are in your community. You might know this person that you're citing. It could be something where you go get a cup of coffee with them and talk to them and say, hey, this is what's going on. We really don't want this to happen. These are kind of internal conversations that you can have as the town board that is an alternative to the citation process. That's something that's really important to kind of consider when we talk about the costs moving forward with it. I mean, it's a net loss situation for the town board, unless you're Somerset and you have enough of these to go around. It's something that you really want to consider is ultimately, what is the goal? If the goal is to get the abandoned junked vehicles out of the person's front yard, what's the best way to get that done? And certainly the citation is something that if you have someone who generally is in the habit of ignoring these kind of notices, if it's been going on for years, and you have someone who's continually just saying, I don't care, it's my vehicle, it's my yard, I pay my taxes, leave me alone. That's a person you might want to cite just because you got to show them you mean business. And it also, as she mentioned, sets a precedent to the rest of your village and town that likely this isn't the only person who has the same type of nuisance. So, the issuing the citation, which we've already kind of talked about, it does look just like a speeding ticket. There's ones you can get from the state. It comes in a book. They have everything on there. There's a lot of information that's actually on the back of those sheets. But each bulleted issues are the parts that you're going to have to fill out, which we've already kind of covered. So I'll gloss past this one unless there's any questions on what any of these mean. I think they're pretty straightforward. Let's see, so as municipalities, the authority that you have to issue citations is somewhat limited. It is to traffic, non-traffic being like the dog ordinance and the abandoned junk vehicle that I keep talking about, and minors, some citations that involve minors. So those are the authorities that the municipality have. Now this notice and delivery of citation is an important piece. As we've already discussed, law enforcement, unless you have your own municipal law enforcement, isn't really an avenue that should be considered as, we'll just have the sheriff take it over, because as we discussed, it's probably not going to be the way it works. Notice by mail is probably the best recommended method. Certified mail is under the statute acceptable way to issue a citation. It's also one that's going to avoid any kind of conflict you might have with the offender. Personal service, for what I just mentioned, is the reason why you probably want to use the mail. If this is someone, and if you know these people, that's another way to kind of maybe guide. If it's a friend of yours, you can go mention to them, say, hey, look, I hate to do this, but this is coming up, we have to deal with it. If it's not someone you know, or if it is someone you know to be kind of an obstinate kind of person, service by mail is going to avoid any kind of conflict, any kind of confrontation that could occur. Most likely this is a person who's not going to want to hear what you're trying to say. If it's about vehicles or their dogs or anything else, they're going to want to protest this. And that's what the hearing or their chance to be heard, that's when that protest can be taking place. Not when it's a face-to-face and during a personal service, which is what people are going to want to try and do. So we would recommend to notice by mail is probably the best method to go through. And again, that notice and delivery is something that should be mentioned in the citation ordinance. Another reason why for having this ordinance posted is it should be available to the public. Your citizens should be able to go to where, whether you have a website or it's at the town hall, they should be able to go and see what the ordinances are and look at them for themselves. So with that said, I'm going to pass this back to Kate to close us up. Were there any questions on that? Okay. Yeah. Oh, I'm sorry.
Can the complainant remain confidential? Whoever makes a complaint to the town?
Well, that's sort of a public records request kind of an issue. There's the assumption that they're allowed to have that information. However, if this is something where you have this kind of a relationship and someone's safety may be at risk, this does not make me any louder, it must be for the recording. If it's a confrontational situation, or if, there are disorderly conducts that can be issued as an ordinance violation that are domestic in situation, or that are something where there could be violence, there could be backlash, maybe that's a situation where you don't reveal the name of the complainant, but that has to be taken on a case-by-case basis, and you have to weigh whether or not the requirement that you be open is outweighed or not outweighed by the safety of the person who is the complainant. Go ahead, Tim.
One thing, Kate, if somebody came to the town board, came to one of you individually and said, Joe Smith down the street won't move that new car and I'm getting tired of it. Well, if the town board issues the citation, you don't necessarily have to say where the initial complaint came in.
That is correct.
So, because you're the issuing agency, not the private complainant.
Right.
And you'd have to then be the witness to it.
Well, and that's when it comes into doing your own investigation. You can take the complaint from someone and not necessarily reveal that, but then you have to have whoever is going to make the record, and Jeff had talked about keeping a record and making a record of why this happens. Then you do someone from the board or, the fire commissioner, the zoning, someone goes out and documents what the nuisance is and makes the file, and that's the person whose name is revealed, or it's the county board is the person. You don't necessarily have to reveal the complainant themselves.
Right. I guess thinking if they request to remain confidential, I don't want my neighbor to know that I'm complaining about him.
Yep.
Can you honor that, or if it's public record, Bob, you came to me, I have to say it was you that came to me?
Terry, do you want to
If I ask.
comment on this?
I can comment on that a little bit. Look, a record is a record, so if someone just tells you something, that's not
Not a record.
So if someone tells you, like Tim's example, well, Joe Smith down the block won't move his junk vehicle, or his dogs bark all night long, that's not a record. That's not anything you have to tell anybody else. So you can keep that confidential. If someone gives you a piece of paper with a written complaint that has their name on it, that's a record.
Or someone sends an email that's, more often than not, I think things fly around by email these days. That is a record.
Exactly.
Yeah.
It's a record. Yeah.
Or a comment in a town meeting?
Well, a comment in a town meeting isn't public record, but the minutes to the town meeting are a public record. So, But I would assume that anyone who's going to make a comment at a town meeting that's a public meeting would understand that they're not going to be kept confidential because they stood up and said it out loud in a group full of people. So, yeah. The other thing that you may want to consider is, depending on what the nuisance is, what the ordinance is, what the violation is, if this goes to, and we're off to court here, if you need witnesses to that, and that is the person who is the witness, their identity will be revealed if it goes to a trial, because I, as the prosecutor, have to prove my case. I have to put the witness on the stand. So it doesn't have to be the original complainant. If they say something to one of the board members, whoever goes to investigate it and documents it then is that witness. So you want to cover yourself that way. We talked about initial appearances. Sometimes your prosecuting attorney has to be there. Sometimes they don't. Different by county, different by municipal court. Check with your courts. If you are there, a lot of times there can be negotiation at the initial appearance with someone, and a deal can be made, and they could enter a plea, or they right then and there. So if you charge with 5 citations and the prosecuting attorney has authority to do so, they can reduce that down to 1 and enter the citation, enter that plea and resolve the case at that time. If that doesn't happen, you set up a pretrial conference. They can be formal, they can be informal, they can be by phone. The prosecuting attorney gets the list of people that pled not guilty, the citations themselves, who have the person who issued them, so they can follow up with them, because at this point, the prosecuting attorney isn't in this from the ground floor up. They don't always know what the background of the situation is. They get the citation, they get the notice from the court that someone's pled not guilty, and then they contact that person to discuss what the situation is and whether or not that person has a defense, whether or not this citation has now finally gotten their attention and they're going to do something to fix it, and we've decided that's enough. We will hold on to this citation, we'll put off the next court date and let them fix it, and if they do, we'll dismiss. I mean, those are things that can happen, but that happens between the prosecuting attorney and the defendant at the pretrial conference. If an agreement is reached, no one necessarily has to go back to court in these because they're non-criminal. You can sign a stipulation. I plead to this. This is what the forfeiture is going to be, and you can submit it to the court. It's then processed through there. If they maintain that they are not guilty and your prosecuting attorney thinks that this is worth pressing and the town board thinks this is worth pressing, then there can be a trial. And the trial is before either the municipal judge in the municipal court or the circuit court judge on their municipal mornings when they set aside time to handle these trials. Municipal trials are generally, I say generally because there can be some issues that end up blowing up and becoming quite large and involved, but for the most part, these are a 1 to 2 hour trial, maybe a morning, and that is handled by your prosecuting attorney. Keep in mind that if you push this to that, you're also paying that attorney for trial prep and the trial itself. So you're back to the cost-benefit analysis. Is it worth it, or is it not worth it to do this? Have you gotten their attention by issuing the citation? And is it worth eating the $5 that the court's going to keep to dismiss it, or is it not? So that's sort of the end of this, and then the collection of the forfeiture. One of the important things is the circuit court's going to handle receiving the fines if they've been ordered to pay one. A lot of times, this isn't just you did something and we want to give you a forfeiture, you have to pay it, you're done. It's something needs to be fixed, right? Something needs to be changed, something needs to be cleaned up. So at that time, it is important for that attorney to have, as part of the decision of the court or as part of the plea, okay, you have now pled to this, you're going to pay a forfeiture of this much, and you have 60 days to clean this up, or you can be cited again. You have 60 days to clean this up, or the city is going to clean it up and they're going to charge you for it. And that's an abatement process that is a much longer conversation for another day, but those are things that need to be addressed at the time. If you don't, and then you end up trying to enforce it later and getting this process in, it is going to be much harder and much more expensive. But there are processes by which, if the city then has to clean it up, they incur that cost and the person does not pay them back, that can be assessed to their property taxes and you can be paid back that way. So you're not without recourse if they dig in their heels even after the fact, but those are things that need to be addressed at court at the time to do it best. Are there any questions? I've been getting waving hands from the back of the room already telling me I'm done, but go ahead.